Good morning. What you're going to hear in the jury charge, in terms of reasonable doubt, you're going to hear reason to hesitate. What you're looking for in this case is a reason to hesitate. And in this case, there are many reasons to hesitate. How about the first one? Every word that was just uttered to you would have been used in a trial to try to convict Chris Dontell of murder. Every single fact you have heard just 7 months ago, and it should scare you, would be used. So let's look at what you're going to hear. You're going to hear, of course, going to tell you about not holding it against the defendant for not testifying, and take that to heart. It's part of your constitutional right. And think about this for a second. When it comes to who didn't testify, you can't consider Meagan Jackson didn't testify, but you should consider the fact that they never put up the chief investigating officer. He never took a stand. You want to know why? He didn't want to co-sign this. He's ashamed of what this case looks like. Because he knows what I know, which is for you to convict Meagan Jackson, you have to believe Chris Dontell. And that's something nobody should have to do. Let's look at what they actually presented to you. Because once you remove Chris Dontell, what you start to see is there's not a whole lot of evidence of a crime, of an actual crime. They've shown to you Meagan Jackson wanted Chris Dontell to have the courage to go tell his wife about their affair. She wanted him to go tell him. That's not a crime. Now, did she do that in ways that maybe we wouldn't agree with? Sure. But her wanting that marriage, that affair to be outed, that is not a crime. And the fact that they're trying to get you over there and make that the case should tell you they have a lot of weakness in their actual case. An actual case requires them to prove things that happened at the time of the crime, which they can't do. Because for 4 years, they've been telling themselves, and anyone who will listen, that this happened at the Myrtle Beach funeral home. It wasn't until 7 months ago that they started telling you it's Flint Lake Apartments. How can you believe and not hesitate when they have shifted the crime scene 4 years later? Does that make any sense to you? So what did they present? Well, they presented some evidence about where phones were. You got some phone information. Okay. The problem with phone information is this. It doesn't put you in the actual what's going on moment. It doesn't tell you if Meagan Jackson drove Greg Rice alive back to the Myrtle Beach funeral home and dropped him off so that he could talk to Chris Dontell. It doesn't tell you she went inside. It doesn't tell you what's actually happening in the moment. And they knew that coming into this case. Do you think it's a coincidence that he wrote a statement out, Chris Dontell did, and hand-delivered it to Ken Marcus, and an hour later, the state has it changed? I mean, he hand-wrote a statement and told the state he did not see it happen. He was not present. He was not there. That is what he told the state. And an hour later, that's changed. Now all of a sudden, he's an eyewitness to it. If that doesn't give you a reason to hesitate, I don't know what else could. I cannot think of something more important than the fact that that man would change his statement within 1 hour to assist the state to try to convict Meagan Jackson. See what that does? It tells you exactly what he's about. He's about Chris Dontell. He's about himself. That's the reason he wouldn't tell Erica. That's the reason he's pushing Meagan. And that's the reason he killed Greg Rice, because he is about himself. What else did they present? Well, look at some of the other investigators. I have never seen the investigators that took this stand. They looked sad up here. They were ashamed of this. And you should be. I mean, you spent 4 years telling everybody this happened at the Myrtle Beach funeral home. And the one thing that changes your mind on that is the testimony of Chris Dontell. That's the only piece of evidence that changed what they believe happened that night. Can you count on Chris Dontell? They shuffled up 2 dentists. I don't know why. They shuffled up 2 ballistics people. I don't know why. I'll tell you, I do know why. Because if you don't have real evidence of what happened in terms of the crime, what you do is you expand this trial. You go put a bunch of evidence in, so when you go back there, you go, man, look at all this. But ask yourself as you're looking at it, does any of it actually prove what happened? You can piece it all together, but when you get right down to it, you're always going to have to come back to trusting Chris Dontell. And that's the one thing the state didn't want you to have to do, but they could never get around that. Let's talk about some of the things they clearly missed. They want you to believe that she returned a wallet and keys the following day. You might have heard that. The wallet and keys are sitting right there in evidence. Guess what you don't have to go with those? A DNA sample. You talk about easy. You talk about simple. Send the keys off. Have the DNA checked. Comes back Meagan Jackson, you might have a little something. They didn't do that. Oh. Make sure you look at that blanket or that sheet. They want to tell you that sheet is evidence that Meagan Jackson had that in her van. Remember what they told you about it? They told you it looked like it came from the Myrtle Beach funeral home. Guess what that evidence was going to look like 4 years ago? 7 months ago. 7 months ago, that evidence was going to be that sheet. That sheet is evidence that Chris Dontell was sitting there in the Myrtle Beach funeral home when Meagan Jackson brought Greg Rice there and he killed him. That isn't a Brian Staff. She worked for Brian Staff Transport. That was a Myrtle Beach funeral home sheet's what they told you. It's sitting right there with Chris Dontell. The reason they didn't like that is because they could never prove to you, and still haven't to this day, what was going on in her mind. But I think we kind of know. She showed up on October 2nd with what? When they went to the shooting range, what did she have in her car? Blow up Betty. She's still trying to woo Chris Dontell. She got blow up Betty. She's not worried about shooting targets. She's looking to have more sex, and that's what their relationship was about. You could pick any night from the time they started dating, and they are together, they are swapping cars, they're having sex in their car. That's what their relationship was about. And she was true to that on the night of October 2nd. That's what she showed up to do. Do I think she wanted Greg Rice to help her out this affair? I absolutely think she did. Was Greg Rice an imposing guy? Yes, he was. If Greg Rice had a chance to talk to Chris Dontell and tell him, hey man, get your stuff straight, I think he'd have done it. Go tell your wife, I think he'd have done it. And that's what Meagan Jackson wanted him to do. She wanted Greg Rice to help her get Chris Dontell to man up.
Objection, Your Honor. This is all arguing facts, not evidence.
Listen, I'll let her go. Thank you, Your Honor. That's exactly what was going on. That's what they've proven to you, is that she wanted this affair to be outed. That's what they had proven to you. And did she go about it the right way? Maybe not, but she wanted it to be outed. What is also true, when we start talking about motive, her and Greg Rice's relationship, yeah, it's typical ex stuff. They talk a little vulgar to each other. You know, they fight over kids. It's typical marital, ex-marital. There's some nastiness in there. But Greg Rice, having him in her life was a benefit to her. They made a big deal out telling you she's not the best mother. Well, guess what a mother who's struggling needs? Help. Getting rid of Greg Rice gets rid of her help. There is no motive there. But think about Chris Dontell on the other hand. Chris Dontell was getting word that he's about to lose Erica, could be losing Meagan, and that Greg Rice is complicating his life and is going to out his affair. There's a text. If he sees Erica, he's going to tell her. So the only person that actually has a motive, a true motive, to get rid of Greg Rice is Chris Dontell. And can you trust him? Can you trust him? Well, let's consider some reasons why maybe not. Got a little list here. Reasons that you should not trust Chris Dontell. He doesn't even recall his plea. He doesn't even recall his plea. He sat up here 7 months ago, took a plea, where he slithered his way out of the murder charge, and he don't remember it. His handwritten statement to Marcus. His handwritten statement to Marcus that he changed within 1 hour. That's the second reason. He sat here and told you he was scared of Meagan Jackson and that he's sleeping with her. After this occurs, and he tells you, she did it and I had to watch it. I had to watch it all. He's sleeping with her. Do you think that that's really, can you believe that? No, you can't believe that. How about this, man? He slipped this right by you. The only person who has Greg Rice's blood on him is Chris Dontell. That's it, guys. The case should be over. The only person with blood on their shoe is Chris Dontell. How about this? He tried to tell you that Meagan Jackson went home after this, went from Lowe's, they went home and she showered. She got all changed up. Had to get the blood off of her. Well, guess what? If you saw the surveillance video footage, when they go back to Lowe's, she's wearing the same exact thing she was wearing when she left Lowe's the first time. She hadn't changed her clothes. She was wearing the same black scrubs. Can't trust Chris Dontell. Who disposed of the body? Who disposed of the body? Chris Dontell. Does he strike you as the kind of guy who's going to do you a favor? Is that the guy you want to go to for a favor? He is the most selfish person I've ever seen. He sat up here and told you he disposed of the body as some kind of favor. You ain't buying that. You can't. You know what? He did a lot. I called him Chris Dontell, full of lies and cries. I'll tell you when he wasn't crying. He wasn't crying when he was shopping in Lowe's. Just grabbing cinder blocks and tarps, stick them in his grocery cart, and let's grab the Pepsi. He was mortified about what had happened. He looked pretty casual there to me. I don't know about you. How about that very sweet wife of his who sat up here and remains committed to him after he sent these heartfelt texts about how much he loved her, was going to stay with her after he killed Chris Dontell. He's still sleeping with Meagan Jackson. Can't trust him. How about the fact he's seen sneaking around looking for a key at a Myrtle Beach funeral home? Can't trust him. How about the fact he lies to Meagan Jackson about where he found that key? Can't trust him. How about the fact that blow up Betty is not very good target practice? Not much of a marksman myself, but I'm pretty sure if you shoot an inflated object, it just explodes the one time you shoot it. That would be the worst target practice I've ever heard of. You would want something that would withstand some gunshots. Can't trust him. And if at all you find yourself in some crazy way wanting to trust this man, I don't think you would. If I told you, he's up here testifying, trying to get his plea reduced. That's why he's here. He's here for who? He's here for himself. That's what he's here. I'll tell you something that really makes me not trust the state, frankly. Not just them having people's phones, but what makes me not trust the state. How about how they're doing you with Chris Dontell? When it suits them, he's their buddy. Hand of one is the hand of all. Meagan Jackson, Chris Dontell's hands, they'll tell you we're in the cookie jar together. Well, then he takes a plea. His plea makes it impossible for him to be charged with murder. The state took his hand out of the jar. Here's what's wicked, man. Here is so wicked. And they bring him back up here and let him testify in a way where they're going to ask you to consider the hand of one and the hand of all. So what are they going to do? They're going to stick it back in the jar. When it suits them, they're going to stick it back in the jar. As soon as we leave here, they take it right back out. That's crooked. See what else they're going to do? They're going to ask you to believe a man they don't believe. They're asking you to trust Chris Dontell, and they don't trust him. You know why this conspiracy charge is gone? The court decided that not enough evidence to support the conspiracy charge to no longer have it.
Objection, Your Honor.
This day,
Move to strike.
I strike that. That's a matter of law.
When it comes down to the hand of one is the hand of all, That is there, and I knew it in the opening statement, from the ringing bell, I knew it. We were in for a wild ride, because when you're trying to count on that to prove somebody guilty of murder, you know you have a weak case. You know you do, man. If you can't put Meagan Jackson on the scene, of course they don't have a scene here, you know your case is weak. I'll tell you what really worries me. It's not that they don't trust Chris Dontell. I mean, I know they don't trust Chris Dontell. You don't trust Chris Dontell. But what I find offensive about their position is they don't trust you. They don't trust you. Because if they trusted you, they would tell you that the case we put up here, the case we put up as the state, banks on Chris Dontell telling you she just jumped out and started shooting. I had no idea what was going to happen. That's what he told you. That is their case. That's evidence they put into the record. But now they want you to just bypass some of that. Wicked stuff. So what happened? Mr. Britton, give us some theories. Well, here's the evidence in the record. Pretty simple. You can consider reverse truth. Very common. Co-defendant will strike up here, testify against their defendant, and tell you exactly what they did, and put it on the other person. Meagan Jackson, sitting in the car with Chris Dontell, they pull up, Chris Dontell gets out and starts shooting. And she had no idea he was going to do it. And that is, you can believe that all day long. That is as likely, and when it comes to motive, much more likely than the fact that Meagan Jackson would get rid of her father, or the father of her children. But that's really not what this case, in my opinion, look, when you look at Flint Lake Apartments as a crime scene, it kind of falls apart. I don't know. I mean, they had a witness who tells you gunshots are fired there all the time. I don't know. Maybe you believe that. Maybe you don't. I find that pretty hard to believe. I find it hard to believe that when they're out there 9 times, nobody says, okay, listen, I'm going to tell you, we got gunshots out here all the time. I heard some, but I didn't say anything to you the first 4 times you were here because I didn't think it was all that important. Because we just, we don't ever report it. I find that extremely hard to believe. I find it hard to believe that they claim she's out there picking up evidence the next day and nobody sees that either. In broad daylight, with her kids running around. That don't make any sense to me. That don't make any sense to me. And it didn't to them either. So you should not feel bad about that. If that does not make sense to you, you should feel good with that. Because it doesn't make any sense. And that's why the state didn't believe it. And that's why the chief investigating officer didn't testify. It's because their original position on this is probably what happened. And then you can read into the evidence. She goes and she picks him up. And she gets him to the Morobich Funeral Home alive. And their problem is they can't tell you what happened after that. They can't blame her. And since the snake has already slithered out of the room, they can't blame him. But I can promise you, as soon as once you make that decision, Flint Lake Apartments is an unlikely spot. You have your reasons to hesitate. And the rest of this case falls at Morobich Funeral Home, where they themselves believe it falls. Dave, the court's indulgence for a second, Your Honor.
All right.
Just in closing, I would just say, when you get back there, what you really follow the court's instructions, but just ask yourself at the end of the day, do you trust Chris Dontell? Because the only way you can convict her is if you trust that man. And I don't think you can. Thank you.
All right, ladies and gentlemen, all of the evidence in this case has been presented to you. The attorneys have made their closing arguments, and now is the time of the trial when I charge you with the law to be applied in this case. The indictment in this case charges the defendant with murder. The court has already dealt with the indictment charging the defendant with conspiracy to commit murder, so you need not consider that charge in your deliberations. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case. It cannot be considered by you as evidence of guilt in this case. Nor does the defendant's arrest, charge, or indictment create any presumption or inference of guilt. This document is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court. The defendant pleads not guilty to this indictment. That plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove her innocence. I charge you that an important rule of the law is that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. Now, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. We know very few things in this world with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think a real possibility exists that the defendant is not guilty, you must give the defendant the benefit of that doubt and find her not guilty. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, my responsibility is to preside over the trial of this case. I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If any testimony was ordered stricken from the record in this case during this trial, you must disregard that testimony. You are to consider only the testimony which has been presented from the witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law for this case. Your duty as jurors is to accept and apply the law as I now stated to you. If you have any ideas to what the law is or what the law ought to be, and your idea is different from what I now tell you the law is, you must disregard your idea of what the law is or ought to be because you are sworn to accept the law and apply the law exactly as I stated to you. In every case tried in this court before a jury, the jury is the sole and exclusive judge of the facts in the case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you're not to infer from what I have said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. As jurors, your duty is to determine the effect, value, weight, and truth of the evidence presented during this trial. Two types of evidence are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves the existence of a fact and does not require deduction. For example, direct evidence is the testimony of a person who claims to have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. You should weigh all of the evidence in this case. After weighing all the evidence, if you are convinced of the defendant's guilt beyond a reasonable doubt, you must find the defendant guilty. On the other hand, after weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. Your duty as jurors is to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses, or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety, or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in this case. You may also consider the appearance and manner of the witness while on the witness stand. Evidence has been presented that a witness has made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. You must decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all of the testimony of that witness or give all or a part of the testimony the weight you think it deserves. Rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to the relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct you and emphasize that the fact the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. The defendant's decision not to testify must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove her innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. Criminal intent cannot be proven to a mathematical certainty. Medical science cannot dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent is present. Criminal intent does not have to be established by direct and positive evidence. Intent may be established by inference in the same way as any other fact, by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from an action or a failure to act. They may arise from negligence, recklessness, or an indifference to duty, or the consequences that is considered by the law to be the equivalent of criminal intent. Now, the defendant is charged with murder. To convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant killed another person with malice or forethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice or forethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time of the act is committed. Therefore, a combination of the previous evil intent and the act is required. Malice or forethought may be expressed or inferred. These terms, express and infer, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person, or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proved beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you, along with the other evidence in the case. You may give it the weight you decide it should receive. If a crime is committed by two or more people who are acting together in committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act, or is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principle is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or scheme is necessary for a finding of guilt as a principle. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principle on the theory of aiding and abetting. Intent is also a necessary element, for there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances for which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. Now, ladies and gentlemen, you may find one of two possible verdicts in this case. No significance is to be given to the order in which I state these verdicts to you. I simply have to state one first and one second. The possible verdicts in this case are either guilty or not guilty. Ladies and gentlemen, your verdict must be a unanimous one. Mr. Roberts, as foreperson, when the jury agrees on the verdict, you will write the verdict here under the verdict portion of the indictment. Then you'll sign your name as foreperson and date the indictment, and then knock on the door and tell the bailiff you have reached a verdict, and we'll bring you back into the courtroom at that time. Now, you have been allowed to take notes during the trial of this case if you wanted to. And I will now allow you to take your notes with you into the jury room while you deliberate on your verdict. However, note-taking is not required. Please remember that some people are better note-takers than others. Juror notes should not be given any greater weight than the recollection of other jurors. The recollections of individual jurors should be considered as reliable as notes taken by any other jurors. Now, I'm going to excuse you to the jury room in just a minute, but I'm going to tell you don't begin your deliberations. I need to check with the attorneys to see if they have any additional charges or corrections to the charges I've given you. If they do, and I deem them appropriate, I'll bring you back into the courtroom and make whatever corrections or additional charges are needed. If there are none, the exhibits will be brought back to the jury room and the bailiff will instruct you to begin your deliberations. But do not begin your deliberations until you're instructed to do so by the bailiff. Also, we have ordered lunch for you. It hasn't gotten here yet, but it should come shortly. When lunch gets here, you can do one of two things. You can stop your deliberations, eat your lunch, and then resume deliberations after you eat lunch. Or if you prefer, you can deliberate while you eat lunch. The only requirement is that everybody must do the same thing. You can't have some jurors stop deliberations while other jurors continue to deliberate. But whatever you choose to do, whether you deliberate while you eat or if you want to take a break, you can do that as well. All right, I'm going to excuse you back to the jury room, but please do not begin your deliberations until you're told to do so by the bailiff. Thank you very much. Any exceptions or challenges to the charges by the state?
None from the state, Your Honor.
All right, any by the defense?
Just a reiteration of our
Objections in hand, one in hand, Your Honor.
All right, I'm going to go ahead and leave that in place and state my prior ruling.
Thank you, Your Honor.
Thank you. Anything else from the defense?
Yes, sir.
Can we,
I'm sorry.
go somewhere where we're 5 minutes away?
Right, if you want to leave, make sure, clerk of court has your, or, my law clerk, or the clerk of court has your number where you can do this, okay?
Yes, sir, Your Honor.
All right, let's make sure we have all of the exhibits
Yes, Your Honor.
right here. Also, if you would go ahead and bring the alternates, and that would be Mr.
Your Honor, with the court's permission, I'm going to take this to my table and just go through and pull out the ones that were not admitted.
I put it in.
Yes, sir.
Big guy.
That's enough. Thank you. Ladies and gentlemen, this is the part of the trial I hate, because the law says that since we still have our 12 jurors, it does not allow the alternates to participate in the deliberation. I hate that because we make you sit through the whole trial just like regular jurors, but then we don't let you make a decision. I want to thank you for your service. That'll conclude your service for this term of court and for this trial. You're at liberty to do whatever you want to do. If you want to stay and see the outcome, you can do that. You've got lunch coming. If you want to stay and eat lunch, you can do that. If you want to leave now, you can do that. If you want to stay a while and then leave, whatever you want to do. We just cannot let you deliberate with the other jurors. Does anybody have anything in the jury room they need to get?
Yeah.
Okay. Please let the bailiff know what it is you need to get, and they'll go in and they'll get it for you. Well, no, we haven't sent the exhibits back. So just go with them, and they can go in and get whatever you want. Come back out. They'll have a place. If you want to stay, you can stay. If you want to leave, you want to leave. If you want to eat, whatever, you can do that. Thank you for your service. You've got a 1-year disqualification from serving jury duty. You've got a 3-year exemption. I hope you don't exercise your exemption, because we do need our good jurors, and I want to thank you for that. As I said, you're free to go, stay, or whatever you prefer to do. All right, thank you very much. It's back at the jury, and you can tell them they can begin their deliberations.
And Your Honor, the jury laptop is here if they need it for any reason.
Okay. All right, anything from the state before we recess?
No, Your Honor.
Anything from the defense?
Yes, sir, Your Honor.
All right, we'll be in recess until we hear from the jury.
Thank you, Your Honor.